This afternoon, we're about to discuss the Title 6 in the Labor Code of the Philippines regarding unfair labor practice. So, in this presentation, it will give a more understanding with regards to collective bargaining agreement or CVA, rights of workers in union, and those prohibits acts as unfair labor practice. So, unfair labor practices is composed of three chapters. The chapter 1 is the concept. The chapter 2 is the unfair labor practices of employer, and the chapter 3 is the unfair labor practice of labor organization. Therefore, the Title 6 of this code is not only for employee who commits any unfair labor practice, but also the employer as well as the labor organization. Now let us proceed to the discussion proper. The concept that is found in the chapter 1 of unfair labor practice. In Article 258, Concept of Unfair Labor Practice and Procedure for Prosecution thereof. So, in this article, hihimayin natin ang general notion or idea on what is unfair labor practice and the procedure na nakapaloob dito kapag tilabag ng isang employee or employer as well as the union na nakasaad sa unfair labor practice of employers and labor organization. So, ULP or unfair labor practices are actions taken by employers or unions that are illegal under the National Labor Relations Act or NLRA and other labor laws. So, some of these rules na nakatakda sa NLRA ay narapat na mayroong ugnayan o namamagitang pakikipag-ugnayan sa pagitan ng employer at ng union. And isa pa dito ay pinoprotektahan ang mga individual na manggagawa mula sa hindi patas na pagtrato ng isang employer or union. So, what is NLRA and why is it set forth as unfair labor practice? So, Congress enacted the National Labor Relations Act or NLRA in 1935 to protect the rights of employees and employers, to encourage collective bargaining, and to curtail certain private sector labor and management practices. So, ang batas na ito ay nilaan upang parusahan ng employer na lumalabag sa nakapaloob sa provision nito at protektahan ang mga manggagawa at employer mula sa pagsali sa mga legal na aktibidad. Binibigyan ng NLRA ang mga empleyado ng karapatang kumilos ng sama-sama upang subuking pagbutihin ang mga tuntunin at kondisyon sa kanilang employer sa pamamagitan ng pagbuo ng union, pagsalo sa isang union or maaari kung hindi man. At upang mapangalagaan ang karapatang ito, nagtatakda ang NLRA ng mga patakaran para sa halalan sa isang union. Sama-samang pakikipagtawaran o tinatawag na collective bargaining. Tumutukoy sa negotiation ng employer at employee na nakasaad sa kontrata na nakapaloob dito is yung pasahod, oras ng trabaho, leave, safety policies, and minimum benefits na may kita sa labor standard. Nakasaad din dito ang terms ng employment on what is the obligation and duties na dapat i-comply ng both parties o ni employer at ni employee. Ipinagbabawal din ng NLRA ang mga employer at union na gumawa ng ilang mga pagkilos na makakagambala sa mga karapatan ng empleyado o sa makagawa ito ng hindi babalanse sa nilikha ng NLRA sa pagitan ng mga union at employer. Ang mga pagkilos na ito ay tinatawag na hindi patas na kasanayan sa paggawa o kung tawagin ay unfair labor practice. So next, why are unfair labor practices is prohibited? So these are among the reason kung bakit ang unfair labor practices is prohibited o pinagbabawal under ng jurisdiction. So first is when they violate the constitutional rights of workers and employees to self-organization. It is considered as prohibited kapag lumalabag sa mga karapatan ng mga manggagawa at empleyado sa pansariling kagustuhan nito na mapaayos ang kondisyon ng trabaho. Second is inimical to the legitimate interest of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect. So, hindi makatwirang paglabag sa napagkasundo ang usapan na nakasaad sa agreement na tumutugon sa pansariling interes ng isang manggagawa at employer. At kung hindi man ay kinakailangan na makitungo sa bawat isa sa isang kapaligiran o sabihin nating sa loob ng opisina na ang bawat isa ay may kalayaang gumalaw o kumilos ng komportable at naaayon sa karapatang pansarili at may paggalang sa kapwa. Third, disrupt industrial peace. Paggambala sa isang estado sa mga relasyon kung saan ang parehong employer at empleyado ay umiwas sa aksyong pang-industriya tulad ng mga welga o tinatawag na strike at lockout na nangangahulugang pansamantalang pagtanggi ng isang employer na magbigay ng trabaho bilang isang resulta ng alitan na makakabuo ng isang paggambala sa kapayapaan ng relasyon o maunlad na ugnayan sa pagitan ng employer at ng mga manggagawa. Lastly, hinder the promotion of healthy and stable labor management relations. Pagiging sagabal o hadlang sa isang magandang samahan at matatag na relasyon ng empleyado at ng management, which means the unfair labor practice ay gumagawa ng unstable labor management relation between the two parties, which is the employer and employee, at dahil iyon sa paglabag ng constitutional rights ng mga workers and employee. Now proceed with the element as still part of concept of unfair labor practice. To consider this act as offense, there should be two elements. First is there should be an employer and employee relationship exist between the offender and the offended. Second is the act done is expressively defined in the code as unfair labor practice. So kinakailangan na mayroong employer and employee relationship na namamagitan sa nagkasala at naapi dahil ito i-required sa first element ng unfair labor practice. Unfair labor practice, as I've said, is a negotiation para sa right to organize ng mga employees that is found in the 1987 Constitution as it protects the basic rights of the workers and their special interests enumerately found in the Article 13, Section 3 in the Labor Code. Ang karapatan na magagamit lamang kapag ang employee ay may relasyon sa kanilang employer na dinedetermine o matutukoy ni fourfold test na ginagamit ng Supreme Court. Which means walang karapatan ang maaaring i-deny o tanggihan na ibinibigay sa batas na nakasaad sa Labor Code kung walang employment relationship sa simula pa lamang. Ito ay dapat na mayroong relasyon ang employee at employer upang ang mga empleyado ay makuha ang minimum na karapatan upang ang mga act o pagkilos na ginawa ay maituring na magkakasala bilang isang unfair labor practice. Ang second element naman ay kinakailangan na ito ay act na bubuo bilang isang unfair labor practice o paggawa ng isang bagay na ipinagbabawal na nakasaad sa Labor Code of the Philippines, na partikular na makikita sa Chapter 2 and Chapter 3 na nakatakda sa Labor Code. So, ito ay isang kasanayan na hindi patas sa paggawa kahit na ang nagkasala ay maaaring isang empleyado, isang union ng manggagawa. Maaaring gawin iyon ng dalawang partido na natatalakayin sa Kabanata 2 at Kabanata 3 ng code na ito. Moving on to the principles concerning unfair labor practice. Not everything that is unfair can be labeled as unfair labor practice because unfair labor practice is a defined term under the Labor Code. Kaya naman, no matter how unfair an act may be, it cannot be called an unfair labor practice unless it falls under the definition of this term under the Labor Code. Ang mga pinagbabawal na kilos ay nauugnay sa mga manggagawa sa karapatan sa sariling samahan at pagtalima sa CBA or Collective Bargaining Agreement o negosasyon patungkol sa magiging kondisyon ng trabaho. Therefore, without the things that I've mentioned, specifically yung elements ng unfair labor practice, without it, ang kilos na ginawa kahit na hindi patas ay hindi patas para sa pagkasanay bilang ito ay legal na nakasaad sa batas. Unfair labor practice has a technical or so limited meaning as it stated that any acts na sasalungat or against the right ng workers to organize, meaning to say na ma-improve pa or mapabuti ang kondisyon ng trabaho nito o makisali ayon sa batas na mga aktibidad sa pag-form ng isang union para sa proteksyon at hiramin ang tulong sa kabuuan ng hangganan ng jurisdictional at ang act ay gaano man ito hindi patas sa karapatan ng offended o naapi, ang kilos kahit gaano man ito makatarungan ay hindi patas sa pagkasanay sa paggawa o hindi considered as unfair labor practice. ULP or unfair labor practice is commonly connotes as anti-unionism or anti-organization of workers when committed by the employer. Karaniwang iniuugnay na anti-unionism or anti-organization ng empleyado kapag ang unfair labor practice ay ginawa ni employer. Also, if it refers to gross violation of CBA provisions. Gross means malicious and flagrant refusal to comply with the economic provisions of the CBA or collective bargaining agreement. Meaning to say, ito ay masamang hangarin at marahas na pagtanggi na sumunod sa mga probisyong pang-ekonomiya ng collective bargaining agreement na magkakasama ng pagsali ng pagsang-ayon sa napag-usapang kasunduan. Maaari ring mangyari ang unfair labor practice sa isang kolektibong sitwasyon ng bargaining kapag tumanggi ang employer na makipag-ayos, binabayaran ang mga abogado ng union o ang mga abogado ng mga opisyal o mga bayarin sa negosasyon, o labis na lumalabag sa mga tuntunin ng nakasaad sa napagkasundo ang agreement. At ito lamang ay applicable kung mayroong napag-usapan ang both parties na sasalungat sa nakasaad dito, which is nakapaloob sa CBA or Collective Bargaining Agreement. And taking note that if the violation are no gross, it shall not be treated as unfair labor practice, but it's an agreeable issue that can be brought to the grievance machinery. Kung ang paglabag ay hindi gaanong marahas, hindi ito nararapat na ituring na unfair labor practice, ngunit ito ay kasakasang-ayon na issue na pwedeng dalhin sa machinery ng hinaing upang bigyan ng mga empleyado at employer ng isang patas at layunin na sistema upang itaas at suriin ang mga issue at reklamo ng walang bias na binibigay sa isang partido. So next, as still part of the concept of unfair labor practice in Article 258, consequently, unfair labor practices are not only violations of the civil rights of both labor and management, but are also criminal offenses against the state, which shall be subject to prosecution and punishment as herein provided. So dahil dito, ang hindi patas na mga kasanayan sa paggawa ay hindi lamang mga paglabag sa mga karapatang sibil ng kapwa paggawa at pamamahala, ngunit mga kriminal na pagkakasala rin laban sa estado na sumasailalim sa pag-uusig at parusa na ibinibigay dito. So, in a violation of unfair labor practice, it has a two aspect. First is the violation of civil rights of both labor and management. Second is criminal offense against the state. So, in civil rights of both labor and management, ang mga taong mananagot ay ang mga opisyal at ahente ng mga samahan ng mga employer, habang sa criminal offense ng unfair labor practice, ang taong mananagot ay ang mga ahente at opisyal na nakisama. Any person who commits unfair labor practice is not liable for such but also criminally liable because unfair labor practice has these two aspects. So, hindi lang liable for civil liability ang taong nag-commit ng unfair labor practice but also criminally liable dahil ayon sa commissions or sa NLRC or National Labor Relations Commissions na may eksklusibong orihinal at eksklusibong jurisdictions upang pakinggan at magpasya sa mga kaso ng lahat ng mga manggagawa. So, moving on to the next slide. So, who has jurisdiction over unfair labor practice? For the civil aspects is the labor arbiter, and for the criminal aspect is the regular courts. So, under ng code, it is the labor arbiter of the National Labor Relations Commissions or NLRC who has jurisdiction or may kapangyarihan over the unfair labor practice for civil aspect na kapag i-claim ay ang pera o sa mga paghahabol para sa aktual na pagdating sa moralidad ng offended o naapi. Huwara na kung saan na yung mga pinsala na tinasa sa legal na proseso upang parusahan ng isang akusado para sa pagkukulang ng isang employer. Bayarin sa abogado at iba pang uri ng mga pinsala na isinaalang-alang bilang isang pananagutan ng sibil na aspeto na nararapat na sa labor arbiter dapat i-file ang case. And si labor arbiter ay nararapat na unahin at ibigay ang buong atensyon nito sa kaso na kinasasangkutan ng isang unfair labor practice mula hearing ng kaso hanggang sa maresolbahan o masettled ang lahat ng issue between the two parties sa loob ng 30 araw ng kalendaryo mula sa oras na sinabit nila para sa pagpapasya. While is it the regular courts which has jurisdiction with respect to the criminal aspect of unfair labor practice kapag prosecute na talaga o kinakailangan ng dalhin sa korte at gawin yung legal na pamamaraan na kakasuhan si offender or yung nagkasala ng criminal charge, then dapat is sa regular courts na i-file yung kaso. And no criminal prosecution under this title may be instituted without a final judgment, finding that an unfair labor practice was committed, having been first obtained. During the pendency of such administrative proceeding, the running of the period of prescription of the criminal offense herein penalized shall be considered interrupt provided. However, that final judgment in the administrative proceedings shall not be binding in the criminal case nor be considered as evidence of guilt, but merely as proof of compliance of the requirements therein set forth. So pagtapos magkain ng kasulatan ni offended o ng naapi, ito ay sisiyasati ng mabuti ng isa sa tinalagang mag-iimbestiga at kung isisiwalat na ang pagsisiyasat ay sumasang-ayon sa pag-iimbestiga, with that, ang kumikilos o nagsasaayos ng kaso ay maglalabas ng complaint laban sa employer or union. Maaaring hilingin ng ahensya na subuking pag-ayusin ng dalawang partido. Mag-i-schedule ito ng pandinig na gagawin sa harap ng hukom ng administratibong batas. Ngunit habang hindi pa napapatunayan na ito ay ginawa talaga ng nasasakdal, marapat na hindi ito gawa ng final na pagpapasya ukol sa magiging parusa nito, at kung ang hukom ay nagpasya na ang employer ay may kasalanan, marapat na magpataw ng anumang kinakailangan na parusa sa employer at maglabas ng naangkop na remedyo sa empleyadong naapi. Kung nalaman naman na si offender ay walang kasalanan, isasara ang kaso at maaaring payagan ng empleyado na magsampa o mag-file ng apela kung hindi sila nasiyahan sa kinalabasan ng desisyon ng korte. So that is the concept of Article 258 of the Code. Now let's proceed to the Chapter 2 of the Unfair Labor Practices of Employers. So in Article 259, Unfair Labor Practice of Employers, it shall be unlawful for an employer to commit any of the following unfair labor practices. Ito ay labag sa batas kapag si employer ay gumawa ng anumang aksyon na nakasaad sa mga sumusunod na unfair labor practices. So first is interference, pakikialam or panghimasok ni employer. That is to interfere with, restrain or coerce employees in the exercise of their right to self-organization. So, si employer has no business meddling with employee on how the employee handle their rights to self-organization. So, walang karapatan si employer na makialam, pigilan o pilitin by using a force or threats sa anumang gustong gawin ni employee with respect on his or her right to self-organization. So, if the employers exercise any of this, it's unfair labor practices. Second is the yellow dog contract condition, to require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. Nangangahulugan lamang na kapag si employer ay hindi pinayagan si employee na sumali sa isang samahan upang mapaayos ang kondisyon ng trabaho nito, si employer ay madali ang matatanggal sa trabaho dahil sa paglabag ng isa sa karapatan ng bawat empleyado. So, isa ito sa typical na pagkatakda ng Yellow Dog Contract ay isang representasyon ng empleyado na siya ay hindi miyembro ng isang samahan o isang union. At isang pangako na nakasaad sa Yellow Dog Contract na ang empleyado ay hindi sasali sa anumang union at pangako na sa pagsali sa isang organisasyon o union ay aalis sa kanyang trabaho. So, those that I've discussed is an example of Yellow Dog conditions that will be also explained further later. So next in paragraph C, which is contracting out, to contract out services of functions being performed by union members when such will interfere with, restrain or coerce employees in the exercise of their right to self-organization. So, when the employer outsources the work na normally na ginagawa talaga ng isang employee, that is considered unfair labor practice. And to be clear na ang outsourcing or contracting out per se is not an unfair labor practice. Ang outsourcing ay isang kasanayan sa trabaho o negosyo ng pagkuha ng tao sa labas ng kumpanya upang magsagawa ng serbisyo traditionally performed in-house ng sariling empleyado at kawani ng kumpanya. So, yung contracting out or outsourcing, as I've said, is not an unfair labor practice. It would only become an unfair labor practice if this contracting out or outsourcing will interfere with, restrain, or coerce employees in the exercise of their right to self-organization. Kung ito lamang ay gagambala o pipigilan ng mga empleyado sa paggamit ng karapatan nila sa sariling samahan, if it has the intention of the employer coupled with anti-unionism, o kung ito ay hangarin o kakagawa ni employer, ito ay considered as unfair labor practice. Meaning to say, si employer ay nakialam sa trabaho ng empleyado niya at ito ay lumalabag sa aktibidad ng union or empleyado, ay kinokonsidera itong unfair labor practice. In paragraph D, company unionism or company domination of union, to initiate, dominate, assist, or otherwise interfere with, or administration of any labor organizations, including the giving of financial or other support to it or its organizers or supporters. So, kapag si employer ay nangingibabaw o nagbibigay ng ilegal na tulong sa pagsuporta sa mga manggagawa sa isang union, ang mga employer ay hindi maaaring magtatag ng kanilang sariling union o makagambala sa mga samahan o union. And para ma-determine o matukoy kung hindi makataruhang kinokontrol ng isang employer ang isang partikular na grupo sa lugar sa loob ng trabaho, nitingnan ni NLRB or National Labor Relations Board ang lahat ng mga katotohanan, kasama kung sino ang nagsimula ng grupo, kung may papel ba ang employer sa pag-organisa ng grupo, at nagpasya ito kung paano ang magiging kalakaran ng grupo. at nagsasaayos ng magiging trabaho kasama na dito ang layunin ng grupo at kung paano magiging pasya ng nasabing grupo. At ang lahat ng ito ay tinuturing na unfair labor practice. Next, in paragraph E, discrimination. To discriminate in regards to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. So, to constitute it as an unfair labor practice, the discrimination committed by the employer must be in regard to the hire or tenure of employment, or any terms and condition of employment in order to encourage or discourage the employee to join any union or labor organization. So upang may taguyod ito bilang isang hindi patas na kasanayan sa paggawa, ang diskriminasyon na ginawa ng employer ay nararapat na patungkol sa panunungkulan ng trabaho o anumang tuntunin at kondisyon ng pagkatrabaho upang hikayatin o panghinaan ng loob ang empleyado na sumali sa anumang samahan. Now, while the law in the Labor Code prohibits discrimination for or against membership, and as it's stated in the Labor Code of the Philippines, that nothing in this code or in any other law shall stop the parties from requiring membership in a recognized collective bargaining agent as condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining. So, ang sapilitan na pagiging kasapi sa isang union na isang kinikilalang collective bargaining agent as condition para sa patuloy na pagkatrabaho na tinatawag na Union Security Clause. So, it just basically means na si employees are required to join a specific labor organization o samahang union which is si collective bargaining agent na magiging representative nila sa gusto nilang maisaayos sa kanilang trabaho. And those employees who refuse to join the labor organization or union may be dismissed, matatanggal from employment. So that is the essence of Union Security Clause that we'll expandedly discuss later.
So next is the discrimination because of employee, retaliation by employer. So the law protects not only the employee's right to join or assist a labor organization, but also the right to testify on matter covered by the Labor Code. If this right is not protected, the right to self-organization will be indirectly defeated because the employees will fear their employer's reprisal by protecting the employee's right to testify the Labor Code. Therefore, shields the workers' right to self-organization from indirect assault by the employer. Thus, it is unfair labor practice to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under the Labor Code. So, let's proceed to the next which is the violation of duty to bargain. Remember that the violation of that duty to bargain collectively is considered as an unfair labor practices. So, next is the paid negotiation. A self-organization and collective bargaining are treasured rights of the workers. So therefore, the law shields these rights for corruption. It is punishable act of unfair labor practices for the employer to pay the union or any of its officers negotiation fee or attorney's fee as part of settlement in collective bargaining or any labor dispute. To do so is not only unlawful, it is ethically reprehensible. Violation of Collective Bargaining Agreement or CBA is an unfair labor practice to violate a collective bargaining agreement. After the CBA is concluded, the implementation follows how implementation is still part of bargaining process, which rests on the parties' duty to bargain, and the duty to bargain requires a good faith. Good faith implies faithful observance of what has been agreed upon the collective bargaining agreement. So it follows that the non-compliance with the agreement is non-observance in good faith of the bargaining. Therefore, the compliance is considered as an unfair labor code. But take note, the violation of the collective bargaining agreement must be gross as required by the Labor Code. Who are those persons criminally liable for unfair practice committed by the employers? So if the employers is only one proprietorship, ang business o establishment ay kanyang pagmamayari. the sole proprietor who is criminally liable for the unfair labor practices, but if the employer is corporation or association, partnership, the persons criminally liable for the unfair labor practice are those officers or agents who have actually participated in, authorized, or ratified the unfair labor practice. Such management prerogative may be availed of without fear of any liability as long as it is exercised in good faith for the advancement of employers' interest and not for the purpose of defeating or circumventing the rights of employees under special laws or valid agreement, and are not exercised in a malicious, harsh, oppressive, vindictive, or wanton manner, or out of malice or spite. But the law spurns anti-unionism, and this legal policy is one of the potent limitations to the so-called management prerogatives. Employers have tried to prevent employees from working together to improve pay, benefits, or working condition. However, it is illegal for them to do the following. Management cannot create its own union dominant and an existing union. Management cannot interfere with the ability of employees to organize a union. For example, management cannot single out conversation about unions and treat it differently than any other non-employment conversation. Management cannot discriminate against employees to keep them from starting or joining a union. For example, management cannot lay off, transfer, or assign workers because they are engaging in protected concerted activity. Management cannot control, retaliate against an employee who provides testimony to the National Labor Relations Board or files a complaint with them. Unfair labor practice, a matter of facts and evidence. Necessarily determining the validity of an employer's act involves an appraisal of his motives. In these cases, motivation are seldom expressly avowed and avowals are not always candid. This thus must be a measure of reliance on the administrative agency. In the first instance, to weigh the employer's express motive in determining the effect on the employees of management otherwise equivocal act. Investigating the facts and evidence from both parties and will then issue an order either dismissing the complainant or ordering the employer to take action to rectify or make amends for the unfair labor practice. This often takes the form of forcing an employer to reinstate a terminated employee or compensate the employee or concerned persons. The law protects information and not only existence of unions. Indeed, if unions are not protected during the conception stage, their birth may not come at all. The following are examples of unlawful acts to discharge membership in a labor organization. Number 1 is the dismissal of union members upon their refusal to give up their membership under the pretext of retrenchment due to reduced dollar allocation. Number 2 is the dismissal of an old employee allegedly for inefficiency on account of her having joined a union and engaging in a union activities. Employees have the right to unionize, to join together to advance their interest as employees, and to refrain from such activity. It is unlawful for an employer to interfere with, restrain, or coerce employees in the exercise of their rights. For example, employers may not respond to a union organizing drive by threatening, interrogating, or spying on pro-union employees, or by promising benefits if they forgot about the union. Unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of the rights guaranteed in Section 7. For example, you may not threaten employees with adverse consequences such as closing the workplace, loss of benefits, or more onerous working condition if they support a union engaged in a union activity or select a union to represent them. Threaten employees with adverse consequences if they engage in protected concerted activity. If it is engaged in with or on the authority of the employees, not solely by and behalf of the employee himself. It includes circumstances where a single employee seeks to initiate, induce, or prepare for a group action, as well as where an employee brings a group complaint to the attention of management. Activity is protected if it concerns employees' interest as employees. An employee engaged in otherwise protected concerted activity may lose the acts protecting through misconduct. Promised employees benefits if they reject the union. Imply a promise of benefits by soliciting grievances from employees during a union organizing campaign. The totality of conduct doctrine holds that the culpability of an employer's remarks is to be evaluated not only on the basis of their implications but against the background of collateral circumstances. Under this doctrine, expression of opinion by an employer, though innocent in themselves, frequently are held to be culpable or objectionable because of the circumstances under which they are uttered. When an employer is being investigated for a violation, it doesn't just look at the accusation, it looks at the employer action over time. This is called the totality of conduct doctrine, and it states that if an employer is blamed for an unfair labor practice, they will consider the employer conduct as a whole. For example, if the company received a complaint from a union employee, they would look into any and all previous complaints, reports, or investigations to make a determination of guilt. The latter is in the position of wrongdoer, having been a party likewise responsible for the damage inflicted on the members of the aggrieved union and therefore cannot justify escape liability. Closure is likewise not legal and the employees cannot be separated if, in fact, there is no closure because the closed department or company reappeared under a new name. If the new or takeover company is, for instance, engaging in the same business as that of the closed company, or one that closed, in such case, the separated employees will have to be employed in the new firm because, in the first place, they should not have been separated at all. Successor employer means a person or entity that acquires all or any part of the company through purchase of assets, purchase of stock, trade of assets or stock, spin-off, merger, acquisition in a transaction that is a change in control, or a person or entity that acquire control of the company in any similar type of transaction. The corporate veil will be lifted, so to speak, and the people covered by the veil will be identified and exposed and be made answerable for the corporate liabilities. Runaway shop is basic example of outsourcing or contracting out, which constitute an unfair labor practice in the runaway shop. It is an industrial plan removed by the owners from location to another to escape union regulation or state laws, or a plan to remove a new location in order to discriminate against employees at the old plant because of their union activities, or to do so a business relocated animated by anti-union rather than for a business reasons. The reasons behind why the job work is outsourced is not really legitimate. It's not really business reason but for anti-union. The employer has an intent to go against or to interfere with the union activities of the employees. Yellow Dog contract requires a condition of employment that the person should not join a labor organization or shall withdraw therefrom. Yellow Dog contract badges. Number 1 is the representative by the employee that he is not a member of a labor union. A promise by the employee not to join labor union. And number 3 is a promise by the employee that upon joining a labor union, he will quit his employment. An employer's decision to subcontract work, even where the decision to subcontract is unrelated to labor cost, is a mandatory subject of bargaining, and that a failure to bargain before subcontracting is an unfair labor practice.
Sa kabilang banda, ang isang employer ay hindi nagkasala sa unfair labor practice sa pagkontrata para sa kadahilanan sa negosyo. Maaari itong tumukoy sa isang pagtanggi sa negosyo, ang kakulangan ng kagamitan o ang pangangailangan ng bawasan ang gastos kahit na ang pagtansya ng employer sa kanyang gastos ay batay sa isang inaasang pagtaas na may iugnay sa unionisasyon. Sa ganitong kaso, ang totoong issue ay hindi kung ang mga dahilan ng negosyo ng mga employer ay mabuti o masama, ngunit kung talagang nauudyok nila ang pagkontrata. Hindi maaaring palitan ng US, NLRB o National Labor Relations Board ang paghuhusga sa negosyo nito para sa pinagtatrabahuhan sa pagtukoy kung ang pagkontrata ay iligal na nauudyok. Halimbawa, malubhang pag-aabuso sa paghuhusga sa kalihim ng paggawa na hilingin sa pamamahala na kumonsulta sa union bago magpatupad ng pagkontrata sa trabaho na tatagal ng 6 na buwan o higit pa. Ang mayroon ng legal na limitasyon sa pagkontrata ay dapat na sapat. Company domination of union. Domination of a labor union usually manifests in the following forms. A. Initiation of the company union. Maaari itong lumayo sa 3 estilo. Una, direktang pagbuo ng employer o ng kanyang kinatawan. Pangalawa, pagbuo ng empleyado sa tuwirang pangangailangan o naimpluwensyahan ng employer. Pangatlo, managerially motivated ng pagbuo ng mga empleyado. Financially support to the union, kung saan ang isang employer ay gumawa ng hindi patas na mga kasanayan sa paggawa kung tinutulak niya ang mga gastos sa union o binabayaran ang mga bayarin ng abogado na nagdraft ng mga gastos sa union o nagbabayad ng mga bayarin ng abogado na nagdraft ng constitution ng union at ayon sa mga batas. C. Employer encouragement and assistance. Ibig sabihin, agad na pagbibigay ng eksklusibong pagkilala sa union bilang isang ahente ng bargaining nang hindi tinutukoy kung ang union ba ay kumakatawan sa karamihan ng mga empleyado ay isang illegal na form o uri ng tulong na nagkakahalaga ng hindi patas na kasanayan sa paggawa. Last, supervisory assistance. Ito ay kumukuha ng form ng paghingi ng pagiging miyembro. Pinapayagan ang mga aktibidad ng union sa oras ng pagtatrabaho o pinipilit ang mga empleyado na sumali sa mga union sa pamamagitan ng mga banta sa pagpapaalis o demotion. Next, discrimination for or against union membership. Ang pinagbabawal ng batas sa ilalim ng artikulong ito ay diskriminasyon upang hikayatin o pigilan ang pagiging miyembro ng isang organisasyon sa paggawa. Kaya kung saan ang layunin ay maimpluwensyahan ang aktibidad ng union ng mga empleyado. Labag sa batas ang diskriminasyon, ngunit ang diskriminasyon ay hindi pareho sa pagkita ng pagkakaiba o pag-uuri. Halimbawa, inuuri ng pamamahala ang mga trabaho at binibigyan sila ng magkakaibang antas ng bayad o mga benepisyo. Ang mga ito ay wasong pagkakaiba-iba na kumikilala sa mga pagkakaiba sa mga kinakailangan sa trabaho o mga kontribusyon. Ang mga ito ay hindi kinakailangang diskriminasyon na bumubuo sa unfair labor practice. Upang malaman o matukoy kung ang isang paglabas ay diskriminasyon, ang pinagbabatayan na dahilan para dito ay dapat na maitatag ang katotohanan na ang isang ayon sa batas na sanhi para sa paglabas ay magagamit ay hindi isang depensa kung saan ang empleyado ay talagang pinalabas dahil sa kanyang mga aktibidad sa union. Sa kabaliktaran, kung ang paglabas ay talagang nauudyok ng isang ayon sa batas na dahilan, ang katotohanang ang empleyado ay nakikibahagi sa mga aktibidad ng union sa oras na iyon ay hindi sa sinungaling laban sa employer at pipigilan siya mula sa pagpapatupad ng kanyang paghuhusga sa negosyo upang palayain ang isang empleyado para sa sanhi. Valid discrimination, union security clause, ay isang term na inilalapat sa anumang uri ng kasunduan sa loob ng isang collective bargaining agreement o CBA na kung saan ay ipinataw sa mga empleyado ang obligasyong kumuha o mapanatili ang pagiging miyembro ng union sa kapinsalaan ng kanilang pagtatrabaho kung hindi ito magawa. Ang layunin ay tiyakin ang patuloy na pagkakaroon ng union sa pamamagitan ng pinatupad na pagiging miyembro. Sa isang diwa, mayroong diskriminasyon kapag ang ilang empleyado ay obligadong sumali sa isang particular na union. Ngunit ito ay diskriminasyon na pinapaboran ang unionismo. Ito ay wastong uri ng diskriminasyon. Union security clause are buried a union shop, kung saan nagpapahintulot sa pagtatrabaho ng mga hindi kasapi ng union ngunit pinipilit ang pagiging miyembro pagkatapos ng ilang tagal ng panahon mula ng kumuha. Another type is or maintenance of membership, kung saan nagpapahintulot sa isang union na humiling ng pagwawakas ng trabaho ng isa na tumigil sa pagiging miyembro. Sumunod is agency shop. Dito, hindi pinipilit ang pagiging miyembro ngunit nangangailangan ng pagbabayad ng isang tiyak na bayarin na karaniwang katumbas ng dapat bayaran sa isang miyembro. Ito ang uri na tinutukoy sa Article 259E. Ang uri na pinakahalagahan ng mga union ay ang closed shop, na kung saan hinarang ang pagkuha ng mga hindi kasapi ng union. Ang lahat ng mga empleyado sa unit ng bargaining na sakop ng isang kasunduan sa closed shop ay napapailalim sa mga tuntunin nito. Dapat silang maging miyembro ng union maliban sa mga sumusunod. Una, ang sinumang empleyado na sa panahon ng kasunduan ng closed shop na magkakabisa ay isang miyembro ng bona fide o mas kilalang good faith ng isang reliyosong samahan na nagbabawal sa mga miyembro nito na sumali sa mga union ng manggagawa sa mga reliyosong batayan. Pangalawa, ang mga empleyado na nasa serbisyo na at miyembro na ng isang union maliban sa nakararami sa oras na ang kasunduan ng closed shop ay nagkabisa. Pangatlo, ang mga empleyado ay ibinukod mula sa closed shop sa pamamagitan ng malinaw na mga tuntunin ng kasunduan. Nalalapat din ang mga pagbubukod na ito sa iba pang uri ng kasunduan na seguridad ng union tulad ng agency shop. Confidential employees, dahil hindi sila bahagi ng ranggo at file bargaining unit, ay kinakailangang nasa labas ng saklaw ng Union Security Clause na tinatalakay na sa ilalim ng Article 255 sa parehong dahilan. Maaring hindi sila hiniling na magbayad ng agency fee. Ang pag-aayos ng Union Security Shop ay nabubuklod kahit na hindi alam ng mga empleyado ang naturang kasunduan. Ang kawalang alam o hindi nasihan sa mga termino ay hindi binigyang katwiran. Ang paglabag sa naturang pag-aayos at kasunod na pagbuo ng isang bagong union. Ang union shop tulad ng itinakdang closed shop ay dapat na mahigpit na ipakahulugan. Sa kaso ng Confidential Sons of Labor, ipinahayag noong April 29, 1960 ang kataas-taasang hukuman na binanggit ang lakas ng union shop o pagbibigay ng closed shop. Dapat mayroong isang malinaw at hindi mag-aalinlangan na pahayag na ang pagkawala ng mabuting katayuan sa union ay maging sanhi ng pagpapaalis. Dagdag dito, dapat na obserbahan ng employer ang takdang proseso. Ang empleyado ay dapat bigyan ng sapat na pagkakataon upang ipagtanggol ang kanyang sarili. Ang karapatang ito ng isang empleyado na maabisuhan tungkol sa mga singil laban sa kanya at magkaroon ng makatwirang pagkakataon na ipakita ang kanyang panig sa isang kontrobersya sa alinman sa kumpanya o kanyang union ay hindi tinanggal ng isang sugnay sa union ng seguridad o isang sugnay sa union shop sa isang CBA o collective bargaining agreement. Kahit nasa palagay na ang federasyon ay may wastong batayan upang paalisin ang mga lokal na opisyal ng union, kinakailangan ng angkop na proseso na ang mga opisyal ng union na ito ay bigyan ng isang hiwalay na pagdinig ng kumpanya o employer. Retaliation. Tulad ng Artikulo 259E, ang paksa ng Artikulong 259F ay diskriminasyon, ngunit hindi katulad ng Article 259E kung saan ang motibo ng employer ay upang panghinaan ng loob o hikayatin ang pagiging miyembro ng union. Sa Artikulo 259F, ang motibo ng employer ay hindi mahalaga. Ang walang katotohanan na pagtanggi niya o kung hindi man nagtatanggi laban sa isang empleyado dahil lamang sa pagpapatotoo ng empleyado ay sapat na upang bumuo ng isang kilos na ULP or unfair labor practice. Ang employer ay maaaring na-motivate o hindi ng isang pag-uugali laban sa union, o ang patotoo ng empleyado ay maaari o maaaring hindi totoo, at maaari o hindi maaaring maiugnay sa mga usapin ng union. Hindi ito ang issue sa ilalim ng Article 259F. Ang batas na unfair labor practice doon ay binubuo sa pagganti ng mga employer laban sa empleyado, anuman ang kalikasan o paksa ng patotoo ng mga empleyado. Pinoprotektahan ng batas hindi lamang ang mga empleyado na may karapatang bumuo o sumali na tumulong sa isang mga organisasyon sa paggawa, ngunit upang magpatotoo din sa mga bagay na saklaw ng labor code. Kung ang karapatang ito ay hindi protektado, ang karapatan sa sariling samahan ay hindi direktang matatalo dahil ang mga empleyado ay takot sa kanilang mga employer sa pagganti. Kaya sa pamamagitan ng pagprotekta sa mga empleyado ng karapatang magpatotoo sa code ng paggawa, sa makatuwid, pinoprotektahan ang mga manggagawa karapatan sa sariling pag-aayos mula sa hindi direktang pag-atake ng employer. Sa gayon ay hindi patas na kasanayan sa paggawa na i-dismiss, ilabas o kung hindi man ay may pagkiling o diskriminasyon laban sa isang empleyado dahil sa pagbibigay o tungkol sa pagbibigay ng patotoo sa ilalim ng code na ito.
Next is the Chapter 3, Unfair Labor Practices of Labor Organizations. Article 260. Unfair labor practices of labor organizations. It shall be unfair labor practice for a labor organization, its officers, agents, or representative. It means that there is an unfair labor practices inside the union between the labor organization and its officers, agents, or representatives, and even its members, to restrain or coerce employee in the exercise of their rights to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. Mali ang pigilan o persahin ang empleyado na sumali o bumuo ng isang organisasyon, bagamat sa isang union, mayroon silang karapatan na gumawa ng sariling panuntunan na nagsasaad ng kanilang kapangyarihan sa pagkontrol sa isang empleyado na kasapi nito. To cause or attempt an employer to discriminate against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership is made available to other members. For example, nalaman ng employer mo na pro or kasapi ka ng isang union. Kaya naman sabihin na natin pinag-initan ka sa iyong trabaho, or worst, tinanggal ka ni employer dahil lamang dito. Next, to violate the duty or refuse to bargain collectively with the employer provided it is representative of the employees. Si collective bargaining ay representative ng mga employees, kaya't labag sa batas na tumanggi si union sa existence ni collective bargaining. Next is to cause or attempt an employer to pay or deliver any money or other things of value in the nature of exaction for service which are not performed or not to be performed, including the demand for fee for union negotiations. hindi maaaring tumanggap o humingi o kaya naman mag-demand ng pera o kahit na anong bagay si union kay employer para doon sa mga proyekto na hindi naman nagagawa o hindi naman naisasagawa. Kasama na dito ang funds para sa union negotiations. Next is to ask or accept negotiation or attorney's fees from employers as part of the settlement of any issue in collective bargaining or any dispute. Ito naman ay ang paghingi o pagtanggap ng bayad para sa negosasyon o bayad sa abogado na galing sa employer bilang parte na ang dalawang panig ay nakapag-areglo na. Lastly ay ang paglabag o pagtanggi na sumunod ng voluntaryo sa arbitration awards or decision na may kaugnayan doon sa implementation or interpretation ng collective bargaining agreement or ang paglabag sa collective bargaining agreement. Sinasabi dito na kapag ikaw ay gumawa ng anumang unfair labor practices, kahit na ikaw pa ay isang officer, member of governing boards, representatives or agents or members of labor association or organization, ay dapat managot sa batas. Unfair labor practices by labor organization are offenses committed by the labor organization which violates the constitutional right of workers and employees to self-organization. Unfair labor practices acts are inimical to the legitimate interest of both labor and management, disrupt industrial peace, and hinder the promotion of healthy and stable labor management relations. Hindi lamang si employer ang nakakagawa ng unfair labor practices kundi na din pati si labor organization. Paglabag sa nakasaad na probisyon ang pigilan o pilitin si employee na gumamit ng kanyang karapatan na tumanggi o sumali sa isang welga. Vina-violate din ni union ang batas kapag pinagbantaan niya o sinaktan niya ng pisikal si employee upang persahin na mag-participate ito sa mangyayaring welga. Nilalabag din ni union ang batas kapag pinilit o pinigilan ni labor organization na magtrabaho ang mga non-strikers habang nangyayari ang welga. Mga halimbawa ng pagpersa sa mga non-striker na magwelga ay ang una, pagbantaan sila ng may halong pisikal na pananakit. Pangalawa, pagbanta sa kanila na mawala ng trabaho. Pangatlo, ay ang harangan ang entrance o exit ng kumpanya. Pang-apat ay ang sirain o wasakin ang mga sasakyan ng mga non-strikers o kaya naman ay harangan sila sa gitna ng daan. Next, ang physically prevents them from working or sabotage the employer's property in their presence. Or in short, creating a general atmosphere of fear of violence and threatening the non-strikers' jobs. Union security clauses are governed by law and by principles of justice, fair play, and legality. But first, what is union security clause? It is when certain employees are obliged to join a particular union as a requisite for continued employment. As in case of union security clause, this condition is a valid restriction of freedom or right not to join any labor organization because it is favor in unionism. Sinasabi dito na hindi pwedeng gamitin ni union officials ang union security clauses laban sa employer lalo na sa kanilang mga members except na lang kapag merong high sense of responsibility, fairness, prudence, and judiciousness. Isinasaad din dito na hindi dapat ma-expelled si union member sa kanyang organization ng dahil lamang sa personal or impetuous reasons. Maliban na lamang ay ma-expelled siya sa kadahilanan ng closed shop agreement. Ang closed shop agreement, ito ay kung saan si employer ay mag-hire lamang ng piling miyembro ng contracting union na dapat magpatuloy sa kanilang trabaho. O kaya naman ay ma-expelled si member ng pusa. Feather bedding or make work. It refers to a labor union practice that requires employers to change their workforce to live up to union regulations. Under feather bedding, most commonly, pinupwersa ni union na mamit ni employer yung hinihingi nilang demand. And mostly na dinedemand nila ay ang pagtaas ng kanilang sahod, seguridad ng kanilang trabaho, at ang health and safety ng mga kasapi ng union. Sinasabi din dito na kakailanganin din ni employer na mag-hire ng mas marami pang employees kumpara sa dapat lamang na empleyado niya. At baka kailanganin din ni employer na magdagdag ng time-consuming policies at procedures para lamang ma-increase yung labor cost ng mga employees. Next is the sweetheart contract. It is an agreement between an employer and a labor union on terms favorable to the employer and often arranged by a union official without the participation or approval of the union members. Unfair labor practices din ng labor organization ang humingi o tumanggap ng negotiation fee or attorney's fee si labor organization kay employer para lamang masettle na yung bargaining issue or dispute nila. Masasabi natin na ito talaga ay labag sa batas. Kapag nangyari ito, ang tinatawag natin na collective bargaining agreement ay magiging sweetheart contract, kung saan hindi maaprubahan ang wages and benefits ng mga empleyado. It's a sweet deal between the employer and union bargainers or union dealers. Isinasaad din dito under the former Article 239 before Republic Act Number 9481 fast-track its amendment. One of the grounds for cancellation of union registration was entering into collective bargaining agreements which provide terms and conditions of employment below minimum standards established by law. But this ground was deleted as noted in Article 247 by Republic Act Number 9481 in 2007. The reason for deletion has not been explained.